There we go. Call the March 21st, 2023 work session to order.
Okay, as you know, this was intended to be in part a continuation of training that was begun in August. I'm going to skip through a little bit of the other part. I think three of you may have heard the original part, and any aspect of this is going to be available for you to review. And I'm looking at Billy primarily, and everyone else for what we haven't gone through already. And I'm always happy to answer any questions you may have during the course of this presentation. Also feel free to present any questions. I'm going to go over real quick some of the initial things I spoke about last time and see if we can't get into some of the new stuff for everyone here. But again, stop me if there's anything that you have questions about. I lose my slide. Yeah, should be. Okay. The first thing I want to, I've got a slide that talks about the nature of the Board of Zoning Appeals. There's two kind of definitions of the types of bodies that may, well, there's three that run government. There's legislative, administrative, and judicial. Administrative is more the staff. Legislative is going to be your city council that passes laws and makes general rules applicable to the entire city. And then there's quasi-judicial or judicial or quasi-judicial. This board is not a judge, but it acts in a quasi-judicial capacity. And what that means is it takes, you all take information presented to you at a particular hearing, take the code and apply the facts to that code and make a decision based on that. You don't take anything that's outside of what is presented to you, which is why we try to get stuff put into the record. Because if there's ever an appeal of your decision, the appeal will be based on what is presented to you. It might be part of the application, might be what someone said, might be a document that someone brought to the meeting, a picture, might be a study, or their physical testimony before you. Those are things that you can consider. And then you just apply the standards, which we'll get to in just a minute. You apply those facts to the standards that you're given by the city code to say whether or not, in your opinion, they've satisfied those standards for granting a variance. Or, and you see in the slide before you, the secondary variance, which is the other type of decision you haven't, many of you haven't heard yet. They appear once a year, once every other year. And those are what they call secondary variances under the code. It's effectively an administrative appeal. And that's basically where someone, usually would be formally by the director of the community development department, will make a decision. Usually it's whether to issue a permit or whether to interpret the code to mean that you have to have 10 feet in this situation, or you need to file a, or get a permit for a particular use that you want to make of the property. Those decisions can be appealed to this board to make a decision. And again, it will be a little bit of a different process, but still it's going to be a matter of you hear what is presented before you and apply what the code in that particular issue says and decide whether or not the community development director made the right decision, made the wrong decision and reverse it, or you find there's a little bit of it somewhere in between. And there's a different process. I don't think I'm going to go through it tonight because it comes up so seldom. I'll go give you an update on that whenever that becomes relevant. Let's see. Now, this is a question that comes up a lot, and I've talked about it before, but it's the precedence of decisions. And what I say is land is legally unique in Georgia. There's case law that says each parcel of land is unique in and of itself, which theoretically means that there's zero precedence from each decision you make. However, don't take that too terribly far, because if you have all of the same characteristics, even though there might be different characteristics, those characteristics are irrelevant. If you have virtually the same property, it's best, certainly, that you provide consistent decisions in virtually identical situations. So while I will say there is no absolute precedence, I would suggest that you should be reaching the same decisions. You know, if you have a 40-foot, 40-foot frontage and, and then the house next door has a 40-foot frontage. Yeah, technically one's, 6 inches deeper than the other one. So they're different properties, but chances are the site distance, the topography, any of the relevant factors are probably going to be pretty close or pretty similar. So likelihood is you should reach the same result. You may not, maybe one's closer to the intersection or not.
So what about, or do the neighbors, how they feel about the variance? Does that come into play if the land is exactly the same?
Technically, how they feel shouldn't necessarily be the factor, but the impact on
Yeah, that's
the
what I should-
neighbors
yeah.
is a factor, and it's specifically identified, and we'll get to them
Mhm.
actually. Get to the variance standards. Here's your general variance standards. These are the ones that every time there's a variance, these are the ones that you need to be considering. And when you're applying the facts to the law, this is the law that you're looking at. It's in the code, section 64, 1883. First standard, does the variance meet the spirit or intent of the zoning ordinance? It's doesn't give you a lot, what is the spirit or intent? Well, you look at the intent of a setback, whatever that may be, the intent of a height restriction, it's to protect the skyline, the visual, it's protect, shade or, impairment of sight lines, those sort of things. If they're not close to their neighbor, if they're for a height, for example, if they're 100 feet from the property line and it's 60 foot tall, they're not really going to be impacting the neighbor, on the angles. You say, well, the intent of the ordinance is still met. They're not imposing anything. That's kind of what that means. It's a general statement. It's not usually the one that one would hang their hat on, but it's out there. The big one is the second one, extraordinary and exceptional situations pertaining to the property such that the strict application of the code, so absolutely applying the 30-foot height restriction or the 25-foot setback or buffer, strict application of that would result in unnecessary hardship due to the size, shape, or topography of the property. And then there's an and that extraordinary exceptional situation is not caused by the variance applicant. So really it's a case of, I've got this weird property, and if you make me put in a 35-foot front setback, I'm going to be pinched and not be able to use my property. Or if I've got a 25-foot or a 35-foot height, I won't be able to get my house in because I'm, on a slope, and whatever the case may be. You're supposed to be looking at, the shape, the topography, or the size. If you've got a small lot and it says you've got to have, so if you've got whatever the lot size is, you got to have 50-foot setbacks all around, and now you've only got 20-foot square left of buildable area, that's a hardship for sure. Where you take that to what is a hardship is not defined in the code. There's no real case law that says what is and what isn't a hardship. It's really going to boil down to, at the first instance, individually, what do you feel? Is it a hardship?
Paul,
Paul,
can you touch on, there was an ordinance change that had to deal with setbacks and whether a property was platted prior to the city being formed or after? I think that would probably be helpful information. Do you recall which?
do you recall which one?
It was in December of 2021, maybe, that ordinance was passed.
Which
Yeah,
ordinance?
the staff will weed those out, and I don't recall exactly the amendment, but the general concept was, I think, that a lot of ones were coming before you where a plat had been approved, but they hadn't built. So the city was saying, okay, you haven't built on your property yet. We've now, before you take any action to build, we have imposed a stricter setback requirement. What the city did was to recognize that, okay, if you purchased a property, we're going to let you rely on what is shown on a recorded plat. under certain circumstances, as opposed to our stricter setback standards. You know, there's specific set guidelines on when that applies and what you have to, show, provide evidence of the plat that was recorded and when you purchased and all of those things. So there's an exception those exceptions should be caught or be presented to staff in the building permit review rather than being presented to you, but should reduce the number that this board is seeing.
I think it actually has, because I don't recall seeing anything in the past year and a half.
I
We had
agree with
one
you.
that was right around the time when that ordinance change happened.
Yeah, that's why I was thinking, but yeah. All right. I popped up a slide and you'll notice it's a little different format. I'm crediting Michael for some slides. He made the presentation before, what was it?
Citizens Academy.
The Citizens Academy. And honestly, it may be, it's probably helpful for you to visualize this rather than just the words that I've put in there about what these criteria are. And the first thing we had there was monetary value. You are theoretically, the fact that it makes the property less valuable or it would cost more money to do it otherwise are not necessarily a hardship. If it makes it impossible to develop the property, because you can throw a lot of money at something and make it work. So to say it's impossible to develop, it's hard to say it's impossible to develop a property. If you throw $3 million at a project, you can probably build a bridge over a wetland and build above it and still be able to use the property. Well, at some point in time, it becomes infeasible if the cost to build that exceeds the value that you might otherwise be able to recover from the property.
But wouldn't the county not allow it to be platted if it can't be buildable?
If you, what I'm saying, there may be, and building in a wetland may not be the best.
Well, just
concept.
in general, I mean, if the setbacks are such that it is now a 20-foot square and you can't build in it.
Yeah,
then-
there may be something that is an instance.
We do have buildable area requirement now with the
Okay.
city to plat, but I don't know what they were doing back then with
Gotcha.
the county.
Okay.
So generally speaking, if someone says it would cost me more to do it, to comply with the code, isn't an absolute hardship, isn't really a hardship. It's if they say it would cost me more than the property is worth to do this, or it would cost me more than I could recover if I sold it, that's where you start to talk about the value being the hardship.
So for example, if we, under a condition on a variance request, for example, we ask for landscaping or something similar to that, they couldn't argue that that's creating a hardship for them necessarily.
Correct.
It's just
Yeah,
part of the cost of building
Yeah, I mean,
or improving.
the rules say you're supposed to do this. If you want relief from the requirement to do that, we're going to provide
Impose, mhm.
some conditions which allow you to do that. And the fact that it costs a little bit more really isn't the hardship to let you get that relief. We talked about not intend the spirit, not caused by the variance applicant. That's typically if someone goes in and a lot of times we think about it, if someone is coming in and splitting a lot and creating one that makes it difficult to put, the stream buffer is taking up the middle of the property the way they divided it. Well, you kind of said that, you chose to divide it that way, put your house where it can go rather than where you want it to go after you've done that. Occasionally, those will come up and sometimes people recognize, you chose your house here, the pool. I think we had a pool and tennis court. They were choosing, they wanted both a pool and a tennis court. The hardship, was that if you choose, we want it front to back rather than side to side. Well, again, that's your choice. That's not really a hardship that we're going to let you recover for. Here's where we talked about the size, that there are exceptions to the minimum requirements for old lots in some cases. So it's possible that the size of a lot might come up. It's rare that the size is really the issue. A lot of times it's more the shape, and a lot of times it's stuff like this triangular shape. Sometimes it'll be the shape maybe comes into play with a stream or an easement or hard rock or something that might come in, that kind of plays into the same general idea of the shape. And then there's topography. That's a big one a lot of times, which I would say impacts the usability of a lot, which, you know, a lot of times you say, hey, look, we want you to build, 50 feet back, but if 50 feet back, there's a steep drop off, then the code might contemplate, okay, this is unusual for this particular lot. We understand it would be very difficult to, or expensive to shore up, 30 feet of steep slopes in order to put a house in. Did you have a question, Laura? Okay.
I'm nodding my head. I
Yep.
understand.
Yeah.
But doesn't that come down to the monetary value? I mean, if they can improve it to make it,
That's
got it.
That's why y'all get the big bucks. Or the titles, I guess. That is the question. Is that a hardship? Or is it just a little bit harder, a little bit more
more
difficult?
expensive.
Is it inconvenient? Is it an inconvenience or a hardship? And you get to figure out where that line is.
Can you touch a little bit on, for example, if somebody wants to add a pool and their primary and secondary septic and kind of the location of that, which may push somebody into a rear buffer, kind of how that deals with hardship? Because that does come up from time to time.
Well, I'd say because well, I have a personal issue of whether or not pools are a hardship in the first place. The requirement to have a pool, I mean, in and of itself, it kind of, in my mind, doesn't really trigger a hardship. But that's Paul, the person that's on this side of the dais, as opposed to someone who's up there. Whether or not you need a pool, is a question of whether it's a hardship at all. Then, if you take it that we're putting in a pool, and the question is, where do I put it, or how big can it be? There are requirements to have a septic and to have a reserve field. There are, theoretically, they should show, I can't put my reserve anywhere else because of the slope or the soils in that location. And so they have to be here. So my pool has to be somewhere else. And, so I can't put it, I can't put it exactly behind it. It has to be a little bit off to the side, or whatever the case may be. So it could play in. That's where those will force the location of an accessory structure or a pool. I mean, if we go to an accessory structure, if they have limited area to put those fields, based on, they should come to you with a soil survey showing that those are the only places I could put it, as opposed to, well, this is where I want to put it. This is where I'm planning to put it. That answer that question?
Yes, thanks.
So do we have the authority to allow them to build a pool in their secondary septic?
I think it would create other problems. I think that's a state requirement.
Yeah, it's a Fulton County.
Fulton County, yeah. Sorry.
It'd be a
State
health
county.
concern.
Yeah, so I would suggest you don't do that.
I think
Would that something we would do, or wouldn't the permit department
Permit
figure out that
department.
it was in their field and deny the,
Right, they
That
wouldn't get the
wouldn't-
building permit.
yeah, that wouldn't come to us.
Right,
We do require them to get approval from Fulton County, and we look at that, we don't make that decision, can you do it or not? It's Fulton County decides that, and we just take that their letter.
I think it's important when we're looking at the plats that are presented to us during the meeting. If the septic is not shown the primary and secondary, we need to factor that into our decision overall. Typically, the staff does a really good job of making sure that it's documented on there. And if it's not, they normally go back to the applicant and ask them for it ahead of time. Just so we've got a full idea of how the entire parcel lays out.
and it keeps from down the line saying, well, I've got permission from one board to violate, permission to violate another jurisdictions requirements. Like, well, if you know ahead of time that they need a reserve field, it's like we might as well address it ahead of time. We can't tell you where to put that reserve field, but if you know it's going there, let's not create a situation where this body has given permission, even though they've got to get all the permissions that they need. Just one isn't enough to override what Fulton County says.
Another example is that would be basically having, if they're in a subdivision, having the homeowners association's approval as they come to us, so we can consider that as well.
Yeah, and I look at that again as, and
We don't need to base our decision based on what the homeowner association says, but it's just an additional level of information that we have available to us.
Yeah.
as
And
we go through
I
the
look
decision
at that
process.
as a part of the substantial detriment to the public good and surrounding properties. Kind of think the HOA is a factor, what the impact is on the neighboring properties and other properties in the subdivision. We're not going to enforce what the covenants are, but you can take into consideration what the other covenants might be and say, well, we think it will be a detriment to the other homeowners if we were to let this, to grant this variance. That's kind of the way I look at it. We're not enforcing it. We're not going strictly by what it is, what the covenants say, but you can take that into consideration as one of your standards, one of your factors. And the last is the public health, safety, and welfare security. Again, that's kind of a general catch-all that there's no real specific provisions, just if it doesn't feel right. Let's see. Yeah, here's a lot. You'll notice, and this is a graphic that you see, I think, coming from staff showing where the neighbors have supported, and that it's not a requirement. It's not a requirement that people have the support of their neighbors, and just because a neighbor opposes it doesn't mean you absolutely deny it. But it's relevant to that factor of whether there's an impact or a negative impact on the neighbors. And you can consider, well, there might be a negative impact, but we'll attach a condition to ameliorate that negative impact. Or you might say there's nothing we can do to make it any less harmful. So it's going to be too much of a harm on that neighbor. But again, that's your decision, not necessarily. The neighbors don't have a veto. The applicant is not required to absolutely get it, but it sure makes your job easier if you know that no one's actively opposing it. And again, you don't have to get it just because everybody agrees. All right, that's the general variances that you'll see. Before I jump into sign variances, is there any other questions before I jump in?
Can a secondary fill line be put inside a setback? I mean,
Yeah,
I think so,
that's
yeah.
fine.
Okay.
So that's-
I mean, I know driveways can usually go right up to the property line. There's-
Right.
So I didn't know if this
so does the
drain
sec-
fill had anything to
they
do
can.
with it.
Yeah. All right. Sign variances, which they come up occasionally, and they're actually a very different standard to a large extent. And as written, and this is what per the code, it says relief from the sign requirements may be granted where existing foliage or structures bring about a hardship. Again, it talks about a hardship. They have to show a hardship. And it specifically says whereby a sign meeting the minimum letter size, square footage, and height requirements cannot be read from an adjoining public road. So theoretically, the variance has to be, if I'm standing on the road and you were to meet the maximum requirements, I couldn't read it. And that's generally what it says because of trees or other buildings. And that's why you need a variance from the sign code. I leave that for you, and that's a hardship.
I think we've had 3 cases in the past 5 or 6 years.
Yeah.
It doesn't come up very often.
But I mean, can they not just move the location so that they don't?
That's where you, I mean,
Okay,
what was
it's
this, the
subjective to-
Starbucks over here?
Yeah.
Starbucks was one.
I think, and it was, I think they wanted to bring it out on front of the deck or something.
I think it had to do with being backlit, maybe, was another one.
Yeah, I think there was something where they wanted to move it from where it was required, or put it on a structure that it wasn't otherwise allowed to be on because it couldn't be seen because the deck, if it was up against the wall, the deck was hiding
below
it
the-
from the road. And it actually did have to do with being able to see it from the road, which was good. But yeah, they don't come up as much. All right. Stream buffers, while they are in a separate section, they do come to this board. They're in Title 20 or Chapter 20 of the code. And you hear that there's a 25-foot buffer, there's a 50-foot buffer, there's a 75-foot setback or impervious setback. What you got is a state requires 25 feet from the edge of the rested vegetation, which means basically where the stream typically runs and pushes the grass. 25 feet on either side of that is absolute, no disturbance, state required. City can't vary that. City can't give you permission to work inside of that 25 feet. Okay. The next 25 feet, or what is often referred to as the 50-foot buffer, the city has adopted an extra protection of the same concept. You can't do anything in that buffer. You can't build and then put back. You can't, use it as your construction area and dig it all up and then replant it. It is to be undisturbed. It's the city's 50-foot stream buffer, undisturbed buffer. Last, there's another 25 feet beyond that, which is usually referred to as the 75-foot impervious setback. That's something that you can dig, you can disturb, you can put plants in, but you can't put impervious. Basically, you can't put any structures in it. You can't put a concrete playground, can't put a driveway in that area, but you can disturb it while you're doing construction. You can replant it.
You can't put a swimming pool.
And put a swimming pool. And those come up, and I will say they have a different list and wording of standards, but essentially they're the same. I mean, it's going to say the property's shape, these are the standards from the code. When a property's shape, topography, or other physical conditions prevent land development unless the variance is granted. It sounds a little bit harder, prevents land development. I mean, but that's kind of what an extreme hardship means in my mind. So you just look at it. It creates an extreme hardship where it would be extremely difficult to develop the property if strict adherence to the minimal buffer were required. And again, the code provides a specific note, which I've included here, and this is straight from the code. Variances will not be considered when actions of any property owner of a given property have created conditions of a hardship on that property. So again, they can't have built their house, they can't build their house 78 feet from the stream and then complain that they need a pool in the next 25 feet if they built. I mean, I say they can't. That's an example of where one might argue that that is a self-imposed hardship that they've created and therefore perhaps wouldn't meet these standards.
Paul, I've got a question for you.
Yep.
So, for example, if we're talking the rear property line of just a square rectangular parcel, is there precedent over the stream buffer setbacks versus the building setbacks?
Okay, they have to meet all of the requirements. If there is a stream buffer, they have to meet that. If the 50 feet, if the stream is off the property and the 50-foot buffer comes in 30 feet, but there's a 50-foot building setback, I mean, they can't do anything in those 30 feet, and they can't build within the 50 feet. So I mean, everything, you lay it over top of each other, and you must meet everything.
Okay.
And if you have to, if you want to go into both, you have to get a variance from both of them. If you're going into both the setback and the buffer and the, rear, if it, a variance to require it to be in the rear yard versus the side yard or whatever, all of those things, which is a lot of times why you see multiple variances for one building, because each one of them theoretically is a separate variance. Yep.
So basically, the first 75 feet is nothing. Next 25 feet, you can disturb, but you have to replant.
50
You
feet.
you can use it, whether you have the 25-foot and then the 50-foot.
Yeah,
So
the
it's-
50 is an additional 25 for a total of 50.
Oh, okay, total of 50.
Yeah.
Okay.
Total of
And then the
50.
next 25, you can disturb, but you have to replant.
Right.
And still
Well, you
can't
don't,
build anything over. it.
theoretically, you don't have to replant, but you can't build anything.
Right, okay.
Yeah.
So, all right.
So in this came up one time, it was, there's different types of streams. There's streams that where water moves in them constantly,
Yeah.
some that are
Ephemeral.
ephemeral. Yeah. So does, or is one, is a stream setback?
The staff will make a determination. If there's a question, if it's identified, they will make a determination of whether it is the type of stream that requires a buffer. There are different, it has to meet a certain level of
Flow?
flow,
Okay.
regularity in order to constitute a stream that gets that buffer.
Okay. So
we don't
you will
really make
include,
that decision. Actually, we rely on the surveyors who are licensed surveyors.
They'll
and
sign
they-
off on it.
They
And-
sign off and they stamp the survey plans and they tell us that there is a creek or a stream here and they put the buffer lines on.
okay. Okay.
Or they sign
that's-
off that there are none.
That's good. So if it's an ephemeral stream, it will say that, and then you all will verify it so that we know.
We don't really go on site, anybody's site to verify.
N-
We rely on surveyors to do.
No,
all
I'm
that.
just talking about the
buffers.
your staff.
Yeah. plan review.
Presentation.
During the plan. review, we
Yeah,
do that.
Jerry, who's gonna be here at 6, he relies on the development engineer to make those determinations, and then he'll review it during a building permit. I will say most of them are 75. Perennial gets up to 150, that's pretty rare. I believe that's Willio Creek, and I don't know the other perennial that goes through Milton, but majority of them are 75.
Okay.
But there doesn't have to be running water. We've
That's
seen
my
one
question.
That there was,
Yeah.
it wasn't even wet, and there was a stream because the state said it was a stream on the plan.
Yeah, I mean, we leave it to experts who sign
Yeah.
their
Yeah,
official.
no, that's what I want to be
sealed-
sure that
Yeah.
we don't have to. Someone's going, when we get your presentation, that's going to be taken care of. So we don't have to ask those questions about the types of streams and.
Yeah, just like when someone submits a survey saying it's 1 foot and 3 inches, they're taking responsibility for that.
that.
Similar
Okay.
to an engineer saying this is what kind of stream it is.
Okay, thank you. That's my question.
I just thought I'd throw this in there, if we get a stream buffer, they have a set of considerations to use when you're looking at those previous considerations about whether it's a hardship and whether, these are just some general, they call them considerations. So you don't render a decision saying it is this, it isn't this. These are just, it might be, there is some odd shape and topography, but there's no, but the proposed buffer is so far away, it's not really that big of a deal. Or there's, everything may work, but the long-term construction is really, in water quality, may be really impacted as far as you can tell. So you can kind of weigh each of these and deciding whether or not there is an extreme hardship based on applying this and whether it meets the intent of the ordinance and whether it's protective enough. So that's generally that. You've been through I've got some, these are set out in the bylaws, largely which where these are pulled directly from. So I'm not going to go through this. I wanted to get to some specifics before we start the meeting in the last 15 minutes and talk a little bit about the specifics of the meeting itself. The meeting guidance rules, you've got the proponents, and you've got the applicant, along with its proponents get 10 minutes. You can ask them questions. And we've kind of tried to work to a process where we try to get all of the time based on their presentation and any proponents, and then ask questions after that so that we can get a good concept of what time they're actually spending in case they go over 10 minutes and we're, well, we were asking questions for 4 of those 13 minutes, so they really still have a minute. Ideally, I know, and we haven't really ever run into a problem with it. Sometimes it just makes sense to ask a quick question, but if we start going into questions, and it'll happen, and I know, Reese will make a long presentation and there'll be a lot of details and you want to, on that map or that plan that you've got, where is it? And, what does that line mean? And, it can make sense, but ideally let them make the presentation. We get staff can have kind of a time. Okay, we've done 8 minutes and now we moved into questions. You might, if possible, wait until after the other proponents and the opponents have spoken. I mean, that because they do get a chance to rebut if they have time left. And you get a chance to ask questions after everybody's gone. You can ask anybody questions. And it's easier to know we're only in the question phase at that point, and we don't have to worry about keeping track of time when we're in the question phase. So once you've heard it all, the public hearing is closed. We should not, both staff and the attorney and the public really shouldn't be providing anything more for you, because that theoretically would be the record. And if you close the public hearing, theoretically, you shouldn't be taking more. You should open the public hearing in order to ask more questions. It doesn't happen all the time for quick questions that are just, informative. Just wanted to make sure, have they filed the necessary paperwork for that? Yes. If you ask staff that, but if you're saying, if you want to get into more the history of the application and what happened, you might theoretically say, this is going to be more of for the public hearing. Let's make a motion to open the you can reopen the public hearing. It's not like you can never get it again. It's just formally you should open the public hearing, motion second, vote to approve, take whatever extra information you can. You can always call someone else up. Just if you want to call someone up after the public hearing has been closed, have a motion to open the public hearing, open it, take your information, ask your questions, give whatever, and then close the public hearing again.
So if we open it up again, do we need to give equal time for those in favor?
Not
and
if you're
those in
just asking
opposition?
questions.
Okay.
Yeah. If you're, I would suggest just only doing that, not saying, hey, I want to hear from more people.
Sure.
Theoretically, you should know
It's a
if
specific question
staff
that's being
has said
asked.
everybody who's wanted to speak has spoken. Usually this board will can extend the time, and that's regularly done. If you get to the 10 minutes or have expired and there's still 3 people that want to speak, and we kind of talked about this, my recommendation is you get a sense from staff, we have 3 more people that have expressed amount of time to speak. Maybe say how many people, by raising your hands are still looking to speak. You see 5 people. Okay. Whoever's on the board may say, look, I want to give everybody a chance to speak. I figure 2 minutes is enough for each person. I'm going to extend it but I would say, I recommend you just extend it for 10 minutes rather than trying to calculate who gets how much extra time. I understand that, the first person may think I'm only going to take 2 minutes and I'm an attorney. I take 3 times what I expect to take every time I open my mouth, but you can probably kind of encourage it to be precise, but have one set time so you can say, okay, we're going to extend the time for 10 minutes for both proponents and opponents. And it's always to make sure that both sides get the same amount of time. And if that doesn't get enough, you can extend it again.
So after we've closed the public portion and we've got a legal question for you, Paul, do we need to reopen it before we ask you the question?
No, I would say if it's just a legal interpretation of what the code requires,
Okay.
no, you would not need to. It's just if it's a factual question that's applicable to the actual application, and some of that may be, if it's procedural of did the application get filed? Was this attached to the file? As opposed to what did the applicant tell you about, if you ask staff, what did the applicant tell you they were willing to do?
Let's open it up. Yeah.
That theoretically that is again more record evidence.
Yeah, and I don't mean to interrupt, but I do agree with Paul on, opening up for people to speak more, because we just recently had training on de-escalation, and
Yeah.
we were told that, it's letting them speak instead of, shutting them down is way better way to go, so.
Yeah, we don't want to push the button.
No, I specifically asked that question, was it a bad idea to announce that we are pushing the button?
Yeah.
And he said, yes.
The first
Oh,
time
it
Todd
is-
ever pushed it, right?
What,
The
I didn't
only
push it.
time I ever heard about it.
Don't announce, you
Yeah.
can push the button, just don't tell them.
Yeah, I think Todd said in 15 years, you never pushed it. So that one meeting.
Wow.
Last
Yeah.
February.
Yeah, oh, I remember it. I was, I was getting up.
Paul turned into a linebacker.
The action of this board is made by virtue of motions that are approved. That is how this board takes action. That being the case, it's important that the motion is clear and that everybody knows what's happening. A motion, in order to be acted on, needs to be seconded. Really, that just means one person can't stall things out. There have to be two people. There's no particular requirement of how a motion is made. It's best if the motion references the particular item that's on the agenda. Whatever you're used to doing has worked. If you reference the case number, and you don't necessarily need to reference the case number and the applicant and the property address and what they requested, and then say what your motion is. You can if you want to. It's sufficient just to list the particular case number and then what you want to do. Be clear about what you want to do. If you want, I always say with conditions, conditions are intended to address the impact of the variance that you're granting. That's the concept. If you're going to grant something that's closer to a neighbor, well, it might be there's a big structure, so let's put some landscaping so they don't see this big structure. That makes sense. If it's a tall building, they put it in colors that are light blue and look like the sky. Just as an example, things that might be the reason that someone would complain about it. You try to address how to make that complaint not as likely to be brought forward. That's the idea. It's not necessarily your chance to design the project the way you want to, but you have in your mind, if it makes the variance palatable and you wouldn't otherwise grant the variance without this, then that's kind of, you do have a fairly free hand. Just because the code says you only have to put in a certain number of trees, well, you can require more trees. If the code says, put the other side back 30 feet, you can say, well, you know what, let's move the rest of the house back 50 feet so that, whatever the situation may be.
Can those conditions come from the citizens that are in opposition?
They can, I think absolutely, they can provide you with their input as to what, they feel they're being harmed and that granting a variance would hurt me, and I would be less hurt, less harmed if you were to do this. And then you can decide that makes sense. We'll tell you what, I won't make them put in 400 trees. I'll make them put in 4 trees,
And then how much of everything do we need to look into, like the future? Like if all the neighbors have said yes to something and then 50 years go by and now all the neighbors are upset that something is there.
You are protecting the city and all of the citizens.
Okay.
That being said, those that are close by and immediate are going to have the biggest impact. It will eventually become something that just is.
Mm-hmm.
So the likelihood of something being complained about 30 years from now is probably less. And someone will have bought in knowing that it was there, and the price of the property factored that in, sort of a deal. So it's yes, you can factor it in, but it's probably less impactful if one were to really think about it. I'll always think in terms of in the conditions that you apply, think in terms of in 5 years, the code enforcement officer going out and taking your condition and going, okay, are they in compliance? So if it says the property shall be neat and tidy, it's going to be kind of hard to say, well, I don't like having the trash cans outside of an enclosure, but is that really a violation? I don't know. If you have a color preference, muted tones, a little bit vague, grays, beiges, and browns, you're starting to get closer. I mean, you could get all the way down to, the code numbers for specific paint colors. I know they exist. I think even Milton may have some of that in their code. I can't remember. But the more detailed you are, the more likely someone can go and make a decision as to whether that condition has been complied with or not. Obviously, at some point in time, you can't do it. You can't redesign. I also don't want you to redesign everything that the applicant does unless that's really what you are expecting in order to grant the variance. I say try not to duplicate the rules in the code. If the code already requires something, I mean, you can expect that they will comply with that. I will give you the exception is it's theoretically possible that the city could amend their code. And if it's really important to you that even if the city amends its code, you want to make sure that they still have whatever it may be, you can put it in there and your requirement will exist even if the city changes its code. Generally speaking, if the city, I mean, this is just my speaking, if the city is changing its rules to require everyone, or to require one person to have it, but not everyone else, I would question whether that's, if you're being a little harsh on that one person. So if the code requires it, I would say you probably can leave it with the code and assume that it's going to be complied with, because the city can go and enforce its own code without having the condition there. One thing on the minutes, I was speaking before we got started to the couple people that were still here. Look over the minutes. The minutes are the official record. If it doesn't say it in the minutes, it didn't happen. Generally speaking, but make sure that, your vote was registered correctly. Make sure that if you made a second, it shows that you made the second. Look through them. You can propose changes to the minutes at the meeting and during the portion where it says adoption or amendment of the minutes, or approval or amendment of the minutes. If you see something that you think is wrong, make a motion to approve subject to the following change. If you see something that's wrong, otherwise, approve the minutes as presented, and that's fine. Staff should pretty much get everything correct. I don't know if they've ever missed anything. Don't recall there being too many changes, but I offer that as a chance to make sure that it does meet what you believe happened, because you can't go back and change your vote. You can't amend the minutes. If I voted in favor and I want to change my vote, it's not the opportunity to change your vote. It's an opportunity to correct that I voted against that. Don't put me down as in favor. We've got a minute or so. Generally speaking, you're here to take evidence and to make a decision. It's not necessarily supposed to be a debate. You're not supposed to necessarily be responding to citizen questions. It's inevitable that it is likely to happen, but the role is for you to ask questions of the people to give you clarification of the facts that you're going to use to decide whether or not a variance should be granted. You're not necessarily supposed to be, like I said, engaged in a back and forth discussion. As I said, it's going to happen, but try to avoid it as much as possible. It's fine. Ask a question, get a response. Ask a question, get a response. If they come up with questions, staff and I will be happy to deal with them, either outside of the meeting or, at a break or whatever is necessary. But this is the chance for people to present their case as to why a variance should or should not be granted. I think, given it's just about 6 o'clock, we'll call that the end of the discussion. I'll just touch, this should be, if you own the property, if you have an interest in the property, that's actually a direct conflict of interest. Please, your duty is to recuse. If you live nearby, consider whether or not you can be fair and impartial in making a decision. And sometimes, if you're right next door, chances are you should probably recuse. If you're just down the street and it impacts how often people drive past your house, might be another situation. If you're on the other side of the subdivision and you never see anyone that will ever see that other property, you can probably just say, no, I can be fair and impartial. If you have any questions, reach out to me. We can discuss whether or not it's a conflict you should consider recusing or not. Happens every once in a while, city's not all that big, and eventually someone may bring something in your neighborhood. Just reach out and we'll talk it out ahead of time. Pretty much it.
Thank you.
Thank you, appreciate it.
I'll let you.